Supreme Court of Law South Session. Honorable Chief Justice Catherine Merriman.
Afide, you may be seated. Justice Merriman is again appearing virtually. She is at home today, but participating virtually, and has asked me to just monitor the courtroom while she's there. Will the clerk please call the case?
This is Supreme Court Case CRA25-009. People of Guam Plaintiff Appellee v. Luke Allen Pangilinan Taitano, Defendant Appellant. Appearing for Defendant Appellant is Attorney Bridget Ann Keith, and appearing for Plaintiff Appellee is Attorney Christine Santos Tenorio. Panel members consist of Chief Justice Catherine A. Merriman, Justice F. Philip Carbolito, and Justice Robert J. Torres. Attorney Keith reserves 7 minutes.
You may proceed, Ms. Keith.
Chief Justice, and may it please the Court. This case comes before the Supreme Court on direct appeal from a jury trial in November of 2024, in which Mr. Taitano was found guilty on attempted first-degree CSC, for which he is now serving a life sentence, and for second-degree CSC, for which he is serving a 20-year sentence, and he has a 5-year consecutive sentences for a vulnerable victim. We're going to ask the court today to vacate the life sentence and resentence Mr. Taitano. The conviction for attempted first-degree CSC is simply not supported by the evidence and should have been taken away from the jury when the defense counsel made a motion to acquit. We are also going to ask that the court review one of the jury instructions that has given rise to some confusion. I will elucidate later about the confusion.
Before we proceed, are you aware of the court's opinion? I know it was issued after you filed your brief in People of Guam versus Simmons, which addresses this jury instruction or this type of jury instruction?
No, and I'm not surprised that there was at trial, counsel was talking about it. I am not prepared to address that, but one of the things that I
think that has a significant effect on your argument. I mean, clearly it's a development.
I made a mistake in my argument because my argument for the jury instruction has morphed into an argument that I think that the trial judge needs to be more careful about his record in the jury instructions, because I didn't have all the jury instructions. And when opposing counsel filed the supplemental excerpts of record, she included 70 pages of an email that I never had, and it's not suitable for inclusion in the record. I'm not objecting to it because it explains how I was turned around in my argument. So I don't have an argument in any event, but I will check that opinion.
It's People v. Simmons, 2025 Guam 13.
13, okay, thank you. Again, I was going to just mention to the panel that I was turned around by the fact that I didn't have a proper record to review the arguments, the jury instruction. I will take a look at that when I sit down. Thank you for that. So regarding the first degree CSC, which is the more important, she was 9 when she revealed, she was a little older than that when she revealed to sanctuary workers that Luke Taitano had been laying down at night and putting his hand in her pants. The testimony elicited a trial and established one incident at the Laddie Heights house where the government has prosecuted attempted first degree CSC, and there were other later incidents that support second degree CSC.
You concede that it seems that you concede that the people could show the specific intent to commit CSC1, but the issue is whether there was a substantial step towards sexual penetration. Is that right?
Exactly. I think that our conversation should be about the substantial step rather than intent.
But you also indicated when you were making this argument that there was nothing in the record of any evidence that the touching that constituted the second-degree CSC was a separate crime from the attempted first-degree CSC. But then, in the government's opposition brief, they talk about them being two separate incidents. One was in Laddie Heights, one was in Jigo.
And for that reason, I believe the issue of double jeopardy is no longer viable in this case. I think the government has conceded. I don't believe that if the first degree CSC was vacated, I don't believe they could bootstrap a second degree CSC.
Yeah. So so your arguments at the onset were on the premise that they were the same incident, but now you understand that they're both, one is in, the second degree CSC was for the Jigo
Later,
incident,
Jigo
and,
incident.
and therefore double jeopardy is not an appropriate
It's not
argument.
inappropriate.
So the only argument that we're facing now is just the sufficiency of the evidence and whether there was a substantial step towards.
That's my position,
Okay.
is that as long as they concede that if the first degree CSC were vacated, the second degree can't spring up in its place. Because I believe when a prosecutor goes forward with this kind of case, they have to choose which one they're going to. But yes.
Let me just, you can just clarify for me, it's not that the government has conceded, it's the defendant. You have conceded that there is no double jeopardy issue in this case now.
Given that the government has identified that they are two separate events entirely, yes.
That's been the case all along in their briefs, as I understand it.
Yes. And if I misunderstood it, the verdicts and the judgment of conviction did not say time periods, and so I thought they might have been. And I don't want for the government to be able to bootstrap second degree CSC if the first degree is vacated, because I just think that, like I say, that you have to choose when you're going in.
So if the only issue is the substantial step and you concede that intent is not an issue, what additional evidence do you feel that the government needs to prove in reference to the incident, in reference to the attempted CSC1?
Yes, what I think the government, what I'm asking this court to ask to set for this jurisdiction is, okay, so first of all, we had a debate about Quintanilla where this court said it's more, we want to look at steps taken versus steps that remain to be taken. So that's our current substantial step test. I really believe that in a case like a CSC where there's not a ton of steps, when it's really more impulsive, that there should be a test, and I'm asking the court to adopt this, that the government must show that he stopped not because of his own volition. Now, I don't know what that evidence looks like in a CSC of this kind.
Yeah, that was going to be my question, was to give me an example of an attempt to commit CSC1 where there was a substantial step.
We have the Quezada case from the appellate division. I mean, frankly, it's up to this court to decide whether this set of facts is enough for a substantial step but I just say that we are presuming that her waking up stopped him.
Is the determination of a substantial step an issue of fact for the jury?
I believe so.
So if the jury made that determination and we have to give under the standard of review, highly deferential to the trier of fact because we don't weigh the evidence or reassess the credibility. And since they found aren't we sort of required to defer to that?
I believe that it was an error for the prosecutor to say he stopped because she woke up, because that was not the evidence. And the evidence was she woke up, and at that time, his finger was not inside her. And so I think that there was just a presumption made, and I think the trial court made a presumption as well. And I think that the evidence that if he did stop of his own accord, he should be given credit for that. That's not a first-degree CSE. And we do not know how long his finger stayed in that location.
But he's not being charged with CSC1. He's being charged with attempted CSC1. And the difference is that there was no penetration.
Correct. But then he should have been, arguendo, that's CSC2. But yeah, in a case like this where there's not a lot of steps, a lot of our substantial step jurisprudence comes from bank robberies and murders and things where there's a lot of steps. In a CSC case, I think that I wish that the government had gotten some proof that she could argue to the jury that, he often acted furtively when his hand was in her pants, or it was fast, or, he kept his hand in her pants. I wish that she had elicited some testimony that indicated to us whether the defendant was sick, because if his hand was there for his sexual arousal, that is not attempted first-degree CSE. And we don't know why he didn't put his fingers in. And that's what I'm saying, is I think that the government made a presumption. I think that the evidence didn't support it, and the judge also made a presumption, and the evidence didn't support it. I have asked this court to try and, in Quezada, you take the totality of circumstances, and I believe that the appellate division in that case made just an assumption.
So walk me through that again. So in the facts of this case, the defendant had his hand down the pants of the victims, and his fingers was in proximity to her vagina in this particular case. And so the argument that the government makes is that the facts are that when she woke up, then he stopped his attempt to penetrate the victim.
Well, I think the argument was when she woke up, his finger was not in her vagina.
Well, I thought that the evidence was that that's what woke her up. It's his fingers in her underwear.
And I will. There are cases that I have to concede that when someone is asleep and cannot give consent, there was a case that I looked at where if you're asleep and can't give consent, then that takes care of it right there. I still think it is possible that Mr. Taitano just simply did not choose penetration, and he should be getting credit for that. He got a life sentence for this attempted penetration. There's no evidence anywhere else in the record that he was penetrating her. And so I just think, I think the presumption is just a step too far, and the court should ask the government in future cases to prove that the defendant wasn't just, because he's allowed to become sexually aroused, not by this victim. And so I do think that there should be a test that includes that he stopped not from his own accord. And I don't think the government got that testimony.
What's your authority for that? What is the basis that what can we point to that supports that argument?
So the Illinois cases that I've cited, Hawkins most of all, which is also a model penal code jurisdiction, where they just say, and there's a lot of cases, not Guam, but cases, Illinois primarily, which is an MPC jurisdiction, and then there's a Mitchell case in Mississippi that says you've got to have you've got to show that it wasn't the defendant's volition that stopped in order to get the conviction. And I just don't think we have any I don't think we have any.
So if the defendant stops and responds to the victim objecting, would that also not satisfy the substantial step towards attempted CSC1?
Yes, I think it's a really fine line. I think if she woke up and said, stop, I think if there is some evidence, yeah, it's a fine line. I just don't think it's up to me to decide that the presumptions are all there, but this panel will eventually have to make that evaluation.
But you know, your argument is insufficiency of the evidence in
Yes.
terms of attempted CSC1, because this went to the jury and the jury disagreed. The jury found that there was a substantial step based on the description of the events leading up to, but not penetration. And so you're wanting us to find that there was insufficient evidence of the substantial step because the defendant stopped on his own volition?
Yes, that is exactly it, but I think that the correct answer is you're going to find that there was no substantial step because there's no evidence that he didn't stop on his own volition. And that's important. A defendant gets credit when they stop on their own volition.
And the credit results in what? Him being acquitted?
Second-degree CSC. In this particular case, because it's not a second-degree CSC conviction, it results in him being the first-degree attempted CSC being vacated. Correct. I mean, they couldn't go back and try this again, so it would be vacating the first-degree CSC. And I think it's because they didn't get evidence that the defendant did not stop on his own, and I think that that is a test that this court can adopt.
What evidence would support that he stopped on his own volition?
I think that might be for wiser people than me. This is a very tough case. Again,
I mean, why couldn't the jury infer, instead of him stopping on his own volition, that he stopped because she woke up and he was, had gone beyond mere preparation, but had
Correct.
taken that final step and, or a substantial step, not the final step, because that's not important, but a substantial step towards proceeding with first degree, but then she woke up and he decided, oh, I better stop
Yeah,
because
but
she's
no-
not sleeping anymore.
the jury wasn't instructed that they had to find that it was her waking up that stopped it. For all we know, he sat there for 15 minutes with his hand in that same place, not penetrating her for his sexual arousal. Okay, that's second-degree CSC. We don't know. And so that's why if the jury had been told that as he's sitting there with his hand inside her pants, it's not penetration until it's a substantial step.
Walk us through the test. You argue that the Eighth Circuit's definition of substantial step is more limited than the MPC, and our law is based on the MPC, right?
Yes.
And so just walk us through that so we can get a better handle on what it is you're trying to assert.
So Quintanilla, yeah, the court, I think Quintanilla was not a CSC. It was a more complicated.
But
fact.
Quintanilla, I thought, just says look at past steps rather
Look at
than-
past steps
yeah.
rather than the future steps. And I believe in Quintanilla, this court took an Eighth Circuit Joyce case and said they're looking at the wrong thing. I think we want to focus on steps that need to be performed in MPC like that. Now, Your Honor, when you asked me to walk through the Eighth Circuit cases, I will note that the government cited Villarreal. I think Villarreal is more a posit than I initially gave it credit for in my reply brief, because Villarreal is about it's about the exact same fact pattern. And so I don't think that Villarreal used the test that Joyce had used that this court rejected. But I still think steps taken, steps not taken, I'm asking for a third refinement to substantial step, and that is tell the jury they have to find that the defendant, if he stopped on his own accord, he's not guilty of an attempt.
Yeah, but my understanding, and you discussed it in your brief, in People versus Quintanilla, there the court adopted, as we stated, the reasoning of the model penal code and cases like United States versus Jackson, the federal case. There, it emphasized that the focus should be on the steps already taken, not the steps that remain.
Yes.
So if the steps already taken is what is the focus in terms of whether a substantial step has been taken, if the only thing remaining is the actual penetration, then there is the substantial step towards an attempted CSC1, if that's what the focus and not what remains to be taken.
I think that is an analysis that is fair. However, again, I think that if Mr. Taitano, there's no evidence that he penetrated in any of the other incidents. We have no evidence of his intent when he's laying there with his finger outside of her vagina.
But you're conceding that the intent to commit CSC, the intent to penetrate, is not an issue. And that what is at issue is that there was no substantial step towards the attempted penetration. And that it was only mere preparatory steps and that it was stopped before there was that substantial step that crossed the line between preparation and penetration. I thought that was your argument.
My argument is we don't know that he didn't just decide this is enough for me. So I don't think the evidence supports the assumption that it was inevitably leading toward penetration.
But the intent was to commit sex,
Yes.
to
We
engage
don't
in
know.
sex, I should say.
Yeah, we don't know because the intent may have been to arouse himself with touching, which is second-degree CSC. That's not first-degree CSC. To arouse himself with touching is second-degree CSC, and clearly that happened, but we don't know then how, yeah, that's what I'm saying, is we don't presume. I don't think we should presume. I think that if she got evidence where, like, maybe when she woke up, she would say, stop that, then that's evidence that she stopped it.
But who's presuming here? I mean, this went to the jury.
Yeah.
They were given instructions in terms of the crime of attempted CSC. You have to have intent and the substantial step towards penetration. And the facts of the case were as described here. And so the jury, as a result of his verdict, was concluded that the remaining step of actual penetration, everything but that occurred in reference to satisfying the attempted CSC1.
Except he may have voluntarily relented.
But if already he crossed the line and then he says, oh, you know, I don't want to proceed any further because she is awakened, the crime has already been committed.
The second-degree CSC offense has been committed. If you have said in there, I don't want to commit the crime because she's awakened. Okay, so then he is guilty of first-degree CSC. But we don't know if he's just laying there with his hand in her pants, sexually aroused, no intention of going any further, which he didn't do on any of the other occasions. And I think that the defendant should get the benefit of the doubt that we need evidence why he stopped. He didn't get put on the stand. He's not going to testify. He denies doing it. So I just think that we need to, refine the substantial step test to require evidence that it couldn't have been him, that he could have relented on his own accord, in which case he is not guilty of first-degree CSC. That's what I'm saying. There is way of looking at these facts that he's not guilty of first-degree CSE, and that was the life sentence, and that makes a big difference in this case. Clearly, he's guilty of second-degree CSE. I just, my only argument is that the court could further refine the Guam test for substantial step to say you have to prove that the defendant didn't relinquish on his own volition. I'd like to quickly go to the jury instruction if I could, because it's a little complicated. So I morphed my argument because, as I mentioned before, the government included in pages 1 through 70 of their supplemental excerpts of record an email. I am appellate counsel. I got all the materials from trial counsel that are on the record under Guam Rule of Appellate Procedure 7A. I got all of those, but I didn't get his emails. So you'll see in my brief, on page 23 of my brief, I said, the record is unclear where this instruction came from, because they were talking about instructions the whole time. But I never saw them until Ms. Tenorio filed her supplemental excerpts of record, and the draft instructions were never on the record. They technically should not be in the excerpts of record. I'm not going to object at this time because it explains to me where these came from. But basically, the judge's law clerk.
Are you referring to jury instruction 4B?
I am. The judge's law clerk sent instructions to the parties, Mr. Tenorio and Mr. Bischoff. They were discussing. They even discussed on the record, and we've both cited places in the
The
record.
suggestion earlier on that People v. Simmons addressed instruction 4B, and therefore, in that particular case, we held that similar instruction was authorized under Guam law.
I'm not surprised, and I just want to say that I made a mistake in my brief because I thought that I had given the court, I argued that the trial judge kept objected to verbiage in the instruction. That was not correct, because I didn't have the
I
record.
see.
I didn't have what they were talking about until she filed her supplemental excerpts of record. Unfortunately, it was not until after my reply brief that I realized, oh, the judge did remove the objected to verbiage. My jury instruction argument, therefore, I don't want to relinquish it, but I do want to say that my objection at this point is that the trial judge should make his draft instructions on the record. There were no draft instructions on the record. I never saw what they were talking about until, frankly, preparing for oral argument. And in my reply brief, I said the trial court did not keep a record of why he kept the second sentence in. Well, that doesn't make sense. Now I see I was the one who didn't see the record they were talking about. And so I was simply trying to further an objection by trial counsel that I realized, because I didn't have the instructions they were talking about, it was unsuitable for me to further that instruction. And so I don't want to relinquish the argument. I want to submit to the Supreme Court on this matter, and I'm glad that the Simmons case has dealt with it, because the parties did talk on the record about how there was a Supreme Court case, and it had to do with Lassard. And in any event, I made just mistakes because I didn't have the original jury instruction that counsel were working with. And the government and original trial counsel had it, because I don't get emails, I don't get all that. So are there any questions about that? I don't move to strike those parts of the excerpts that are not proper, but I will say an email that is nowhere docketed should not be in the record. I'm grateful she finally told me what they were talking about, because I didn't know. If there's no more questions, I'll let the government start and reserve some minutes. Any questions? Thank you.
Questions?
Madam Chief Justice, may it please the court. When reviewing the sufficiency of the evidence for the attempted first-degree criminal sexual conduct, it is important that we review the record and exactly what came into the record via JB's statements. JB testified he tried to finger me, and then she explained that the tip of Taitano's finger was almost in her hole, like he was about to stick it in. JB explained that his finger was going down from the part where she pees down to her hole, and then it was at that point that she woke up. And the reason why that's important is because when you juxtapose JB's testimony with underlying the attempted first-degree CSE with her testimony with regard to second-degree CSE, it's very clear that the facts are different. The appellant argues that this is just a second-degree CSE, but I don't think the record shows that, because when JB recounts all the other touchings, all those touchings are him touching her vagina. There's not any specific mentions of fingers. There's no mention of holes. So JB's testimony by itself is she believed that the Laddie Heights incident was different in that incident, he was not merely touching her vagina, he was trying to stick his finger in her vaginal hole. Now, about the substantial step, for sufficiency of the evidence, this court in Quintanilla said we look at the steps already taken, and it has to be beyond mere preparation. So this case would be different if the defendant, we knew that he said out loud, I want to finger her, but then he didn't do it. There's no substantial step taken. There's no mere preparation. This case was he was actually in the middle of doing the act, and he would have completed but for the victim waking up. Now, Ms. Keith wants this court to adopt a test, but I actually think that that is waived on appeal because the issue came up as sufficiency of evidence, not that this court should review its precedent regarding what constitutes a substantial step. We gave the test to the jury, we gave them the definition of substantial step, and that is not a legal issue, that is for the trier of fact. We give them the test and the definition that says that he performed a step or omitted to perform a step that would have been a crime if not otherwise interrupted, essentially. So Ms. Keith's encouragement of this court to adopt a departure from his own volition approach, that simply was not the test at the time that we did this trial. So even if she wanted this court to adopt the test, we were going by what substantial step was for the purposes of the state of the law at the time. But even at that, if you consider the Eighth Circuit's approach wherein this court in Quintanilla said we're not going to adopt that approach, even under the Eighth Circuit's more limited approach of last proximate act, in the Villarreal case, the Eighth Circuit said that in that case where the defendant was attempting to penetrate the victim and the only reason why he was thwarted was because the victim woke up, that was sufficient evidence for their substantial step test. So even if we are going by the test that Ms. Keith would like this court to adopt, the facts were sufficient here. Now, she keeps saying, well, she wishes the prosecutor would have elicited something, some more facts. This court has repeatedly stated in People v. Morales and in subsequent cases that it is impossible to get into the defendant's mind. We can't elicit facts of the defendant's mind because he has a right to remain silent, so we can't do that. And so the jury is always told that. The jury is instructed that they are to infer his purpose based on his conduct, and that is what the jury did here, was that they inferred the purpose of well, they inferred that he was taking substantial steps to commit this penetration upon JB, and that was within their purview. So that, being that that's for the trier of fact, even if this court is reviewing de novo, there is no legal basis to say that the facts here are legally insufficient to sustain a substantial step. And there are two CSC cases wherein this court has analyzed what is a substantial step for penetration. The first one being Ellert. In Ellert, the facts were that the defendant approached the victim from behind and put his finger in her hole, in the leg hole, or the leg hole, and then it touched her vagina somewhere. This court stated that that was sufficient evidence for attempted third-degree criminal sexual conduct. Again, in People v. Flores, this court stated that there was sufficient evidence for attempted penetration, when the defendant picked up the victim, dragged her to the bedroom, and said, "I want to have sex with you." And I think that arguably the facts here are more solid on the grounds of an attempted penetration versus mere preparation. He wasn't merely preparing to do it. And there would be no other facts to elicit, because this is a case where we have a 9 or 10-year-old witness. She can only say what she experienced and what is going on in her head, and she told the jury he was trying to stick it in. So I don't think this is a mere second-degree CSC situation, but I believe that even under the case law that Ms. Keith cited, that this is sufficient evidence. In the case law that she cited, I think it was DeCallaway, there, the court held that there was insufficient evidence because nobody disrobed, and even though the defendant was taking nude photos of the victim in that case, and he said he wanted to have sex, that wasn't sufficient. That is clearly not the case here. There are solid facts that we could point to in the record that shows that this was an attempted penetration versus a mere touching.
But if in this instance, the defendant had put his hand in and, did nothing more, would you still make this argument that there was a substantial step towards penetration?
No, and that is evident as far as the other touchings, because if the victim had never stated that she thought he was trying to finger her and that his finger was about to go in her hole, like he was about to stick it in, we would not have charged first-degree CSC, because there would have been no substantial step.
So that was the evidence of the substantial step towards complete performance.
Correct, that she said he was about to stick it in. In cases where all we have is that the defendant is merely touching the vagina, that would only be permissibly charged as a second-degree CSC. So that's the argument here. I think it's waived that we can't say that this court should alter the test. Also, alter the test with regard to CSC alone. I think that the jurisprudence doesn't allow for that. If we have a substantial step test, it's going to apply to all cases, but even under a stricter approach, this still would have been sufficient. And even if this court wanted to adopt a different approach, I think that's dangerous, because if the focus was on the steps remaining to be taken in CSC cases, the only one that could answer that is the defendant. And so that would be an unfair test, because as this court has noted, there's no way of getting in the defendant's mind. We can only go by what the victim believes is occurring to her. And that's essentially my argument with the substantial step. I do want to put on the record with regard to the jury instruction 4B. I understand and I know why Ms. Keith did not have the appellant's record. I would also prefer that the jury instructions are on the record below. I've asked the trial courts to, when the bench conferences are happening, I've asked that everything be on the record. But I do agree that the draft instructions should be on the record and not in email form. But I just wanted to make very clear my position on this. To the extent that Ms. Keith was not talking about the victim's testimony need not be corroborated, I just want to highlight that when that was removed and we're talking about the jury instruction about the sufficiency of one witness testimony, which is different from the victim's testimony need not be corroborated, that tracked the law. So there was no flaw in the jury instructions here, and the jury did not get the instruction that the victim's testimony need not be corroborated here. And because the other issues are moot, I believe at this point, that's all the arguments that I have.
Thank you.
Ms. Tenorio?
Yes, Your Honor.
I'm a little intrigued by Ms. Keith's argument that the other instances showed the defendant had a propensity to touch the minor only for sexual gratification. Should the jury have been given an instruction about how to deal with other similar situations?
No, Your Honor, and I believe it's because the other act was a charged act. So they are given an instruction that their verdict on one act doesn't affect the other act. So I think it would have been confusing to them to the way to treat that evidence. But I think that based on the facts alone, when the jury was reviewing this, yes, they are reviewing his conduct and how different it was, the conduct underlying the second degree CSC, because all of the other conduct, he's merely touching it. That's how she described it. He's touching, he was playing with her vagina. That's what she said. But she never said he almost stuck it in. She never described it as he was about to finger me. She did not describe it, and I think that's what makes the difference. But I do not believe that a jury instruction on how to treat that evidence would be appropriate because the jury is instructed that their verdict on each count is separate and apart from the other counts.
But in this particular case, even though we usually don't want propensity evidence there, the propensity evidence that Ms. Keith's discussing might have aided the defendant in his defense, and did we improperly deny him that?
The propensity evidence as to his prior CSC conviction?
No, I'm sorry. That his prior acts with this victim were only for touching for gratification, if we presume that for sake of argument.
So I think that if the victim had not stated that he was going to penetrate her, that would have been chargeable as a second degree CSC, and we would have been able to prove the sexual arousal or gratification because the jury found him guilty of one count of second degree CSC for the GIGO act of second degree CSC for sexual arousal or gratification. But I don't think that the jury would, I don't think there is a basis in law that the jury could be instructed that his acts underlying one charge could be considered in determining his intent for another charge, because those are two different incidents. They occurred at two different places and due to separate periods of time.
Thank you.
Thank you. Thank you, Your Honors.
Thank you, Mr. Tenorio. Ms. Keith, you have a minute.
Oh, I want to just say, the victim did not say he was trying to stick it in. The victim said, he tried to finger me. He was almost in her hole. He was about to stick it in. That's different than he was going to stick it in. She doesn't know. And I just wanted to make that distinction. The other thing is Attorney Tenorio doesn't want to change the substantial step analysis. That's not what I'm proposing. This has always been out there. In law school, we studied when does the defendant abandon, because abandonment is a defense to a crime. And so In law school, we studied whether the attempt stops because the defendant voluntarily gave it up. So this body of law has always been out there. It's just never been discussed in Guam in this particular context, but it's all over the place. And like I say, I brought Illinois and Mississippi cases into it because that's what they did. If there's no further questions, I'll submit. Thank you.
Do you have any further questions, Chief Justice?
No, thank you.
All right.
Thank you.
All right. The court will take the matter under advisement. We'll now stand adjourned and we'll issue a written opinion.